Just let me get it down. Yes.
Yes.
Huh.
May I please, Lordship,
Hmm.
I beg to mention item number 1.
One.
Yes, my lord, here I'm yet to file affidavit. So kindly allow me 3 weeks time, my lord.
Acha, this is repetition criminal. Affidavit in reply was not filed.
Yes,
Uh,
affidavit in opposition, my lord, on behalf of the state.
Otherwise, in the order sheet, it is written reply, affidavit in reply to the. Okay. Here, 2 children died, right? In this
Yes,
matter?
my lord. Yes.
Okay. So, Mr. Yes, your name, please.
Papum.
You are for the government.
Yes, my lord.
Okay. Ms. Tipapum, appearing for the respondent number 1. No, not Union of India is 1.
No, I'm for the respondent number 3, 4, and 7.
Appearing for respondent number 3, 4, and 7. You have taken consent from all
Yes, my
the
lord.
parties?
Yes, my lord.
Okay. Petitioner side also?
Yes, my lord.
Okay. Appearing for so-and-so, prays for some time to file
3 weeks time.
affidavit. 3 weeks time.
Yes, my lord.
To file affidavit in opposition.
Yes, my lord.
Opposition, prayer is allowed. List the matter after 3 weeks on a date to be fixed by the registry.
Yes, my lord. Much obliged.
My pleasure, Lordship. I beg to mention here in item 10 and 11.
10 and 11.
Yes. Here I'm informed by the leading counsel that the client has already engaged in new counsel. So if we may be allowed to withdraw.
New
from-
counsels are appointed.
Yes, yes, yes.
Acha.
And the brief are also already being handed over.
Acha.
So-
You are no longer there.
Yes, yes. So if I may be allowed to withdraw my
Acha.
wakalat, the leading counsel as well.
Okay. Miss, you are T.
Yes,
Sukru?
yes, yes.
Yes. Miss T. Sukru, appearing for the petitioner, informs this court that the petitioners have engaged other set of counsels. And as such, she prays that her name may be withdrawn from the. Actually, in withdrawing the name, I think you have to tell the registry.
But
Yeah,
Chief can give
withdrawing your
direction.
name from the matter
yes, yes.
is there. I think registry needs to be informed.
Yes, Lordship, but there should be an order from the court as well.
She prays that her name may be withdrawn as she knows she is no longer appearing in the case, and let the matter be listed after 2 weeks.
Lordship, not just my name, but there are the leading counsel's name is also there as well.
Actually, your
Yes.
name is only on the board.
Yes, yes, it's
Acha.
only reflected here, but there are some more counsels, the leading counsel as well.
Her and the leading counsels. Withdraw her as well as her leading counsels from the case as they are no longer appearing. Right? And rest, I think you should make an application to the registry.
Yes, yes.
I have just reflected this.
Okay, fine.
List
Much
the matter after 3 weeks. 3 weeks, Kado. 3 weeks.
Obliged, Lordship.
Please, Lordship. First, I'd like to mention item number 2 and 3, Lordship. I'm making a mention on behalf of NK Liukam, who's from Dimapur. He's indisposed today, Your Lordship. So I've taken the consent from the other party also. So if this matter can come after 2 weeks.
Some additional evidence
Yes,
the
yes, that
petitioner
I-
wants to put.
Yes.
Okay. Mr. So-and-so, you're for the petitioner?
I'm for the
Applicant.
respondent number 2 and 3 in the main petition. And in the IA, I'm for the applicant.
Yes.
Yes.
You're right, Mr. So-and-so, appearing for the applicant in the IA, you're right. Prays that the leading counsel is indisposed.
Yes, NK Liukam.
Leading counsel is indisposed, and as such, he has prayed for some accommodation. The prayer is allowed. List the matter after 2 weeks.
Yes.
2 weeks.
Much obliged, Lordship.
Wait, please, Your Lordship. I beg to mention hearing item number 9 on behalf of my senior and Nogomar. Kindly, yes, Your Lordship. Kindly this matter be listed after 2 weeks since my senior is indisposed.
You are for the petitioner?
Yes, Your Lordship.
You have informed the other side?
Yes.
Yeah, there. Okay. As prayed for by Ms. So-and-so, appearing for the petitioner. List the matter after 2 weeks. 2 weeks. And so are present. You are for the Union of India?
I'm for the respondent number 2.
2. Counsel for respondent number 2. And you are also there in this? What?
For state respondent.
Oh, yes. And so for so-and-so for rest state respondents are also present.
Obliged.
Hey, please, Your Lordship. Lord, I beg to mention hearing item number 7. If the-
7.
Yes,
Acha.
my lord, if the matter can come up after 2 weeks, my senior is indisposed. She's applied for leave. She's on leave.
Okay. Mr. So-and-so appearing for the appellant.
Appellant.
Appellant is Union of India and you are the other appellants.
No, you're not. I am for the appellant.
Acha.
The Union of India is respondent.
But it's written Union of India and 4 others are the appellants. Acha, so-and-so for the appellant states before this court that his senior,
MS
The
Nuksumtila. MS Nuksumtila.
Nuksum Tilla,
Yes.
is indisposed. And as such, he has prayed for some accommodation. The prayer is allowed. List the matter after 2
2
weeks.
weeks. Much better.
May I please, my lady?
Yes.
My lady, I'm appearing from VC. My lady, I beg to mention hearing item number 12. My lady, 12, yes.
Acha.
My lady,
Hmm.
as per last order, it was prefixed on 21st of this month.
Hmm.
However, due to my ill health, as I'm suffering from typhoid, I have also informed the other side.
Hmm.
So the consent to get it listed on 8th of August, if your lordship may permit.
Okay. This is for enhancement of the awarded amount.
Yes, my lady.
You are for the petitioner.
No, I'm for the respondent company.
So you are there.
Oh,
You are
Yes,
there for the petitioner.
Yes, yes.
Hmm,
Appellant.
acha.
Appellant.
So you want it to be listed in the month of August.
yes, I have the consent of the principal counsel for the appellant
Mm-mm.
on 8th of August.
As prayed for by Mr. Vikramjit Devnath.
Vikramjit, yes, my lady.
Vikramjit Devnath appearing for the respondent, that is Oriental Insurance Company. List the matter on 8th of August. List the matter after 2 weeks. Or you want a specific date?
No, as senior colleague, Mr. Sharma will be coming from Lakhimpur. So even he also requested to fix the matter on 8th of August. So
Okay,
if it is convenient with this honorable court.
It's okay. What is the day? 8th of August is?
Friday.
Friday. Okay. List the matter
Yes,
on.
it is Friday.
Okay. So and so for the
Amen.
petition. So present.
For motion from the supplementary cost list, item number 13.
Item number 13. Why? Council's not there. Item number 13. Nobody is appearing. Younger Wati. Acha, none appears for the petitioner upon call. You are there. Item 4.
Yes.
Yes. This is
Item
like
4.
I for what?
Item 13. This is for
For impleadment.
For implement.
Yes. You are impleading the which parties?
Lordship, you must see respondent 1 and 2. The sole respondent has expired. And 1 and 2, they are the director of the Quashing Private Limited.
Ah. There was, yes, a respondent was a sole one.
So
There was
yes,
a
the sole respondent, that is the proprietor, he expired. And the new, the respondent number 2, they are the directors of the infirm. So I want to,
Directors of a company, which is,
directors of the company, yes.
and then you are into arbitration.
Yes.
You want the arbitrator to be appointed.
I first let them be deleted as party respondent and then this
And
may be issued.
allow it, then you have to change the cause title. in the main
I have to
petition.
implead the parties first, so let me implead this is the first time the matter is coming up. So the respondent 1 and 2 may be impleaded as a party respondent. I'll take steps, then thereafter, necessary orders may be passed.
Heard Mr. So-and-so for the applicant. This is an application for impleadment of two respondents,
Yes, Your Lordship.
namely one, Ratan Lal Sharma, and two, Anthony Andrew D'Souza, who are the legal representatives of MS Quadricon
Quadricons. Private Limited.
Quadricon Private Limited
Later.
as party respondents. The counsel for the applicant states that the respondent, the erstwhile respondent expired,
Yes, Lord.
and as such, he has filed his application for impleadment of the new respondents. Issue notice. Not required, you can implead it. Right, notice is not required. You change the cause title.
Because they have not issued, that they are not aware that this petition is pending, so let a notice be issued.
Okay, but then the fact is they has to be impleaded.
Yes, Lord.
It has to, otherwise there'll be no purpose.
Yes, Lordship.
Issue notice. Returnable within
4
2
weeks.
weeks.
4 weeks because it's in Bombay.
Where? They are in Bombay.
They
Himachal Pradesh.
they are in, one is in
Himachal Pradesh.
Himachal Pradesh, yes.
Returnable
and
by
March.
4 weeks. The petitioner is allowed to take steps for service upon notice. By the registered post
I
with
know,
AD,
Why not?
as well as usual process.
That's not
List the matter after 4 weeks.
work is much obliged. Lordship.
For motion, item number 14.
There's a delay of 511 days.
Yes, Your Lordship.
Let the notice go. Today it has come up for the first time.
Yes, Your Lordship.
Heard, Ms. So-and-so? For the applicant. This is an application seeking condonation of delay of 511 days in filing the appeal, connected appeal, challenging the judgment and order dated 7/12/2023, passed by the learned member of the Labor Commissioner cum Employees Compensation Commissioner, Kohima, in compensation case number 2 of 2022. Issue notice to the respondents number 1 to 4. Returnable within 2 weeks. They are stationed where?
My Lordship, I make it 4 weeks.
Acha. Otherwise, they are stationed where?
Some are in Dimapur, some are
Nearby. Okay, returnable by 4 weeks. The applicant to take steps for service of notice upon the respondents number 1 to 4 with by registered post with AD as well as usual process. List this matter after 4 weeks.
Please, Your Lordship.
For motion, item number 15.
Nobody is there for Union of India? Or this is state of Nagaland's I government advocate is not there. They want some extension of time. Okay, call it after some time. In the meantime, just call the one government advocate. Call it after some time.
For admission, item number 4.
Maybe the addition.
What is this about?
This is an application for quashing the FIR and charge sheet.
Acha, okay. PP is there? You are PP?
Oh, you'll,
Yes.
For the respondents.
for the respondent 2 and 3.
Respondent two is.
Complainant and the
Complainant
alleged
and
victim.
The one PP should be here. Call one PP. Yes, Mr. Courtmaster. Call one PP. Okay, one public prosecutor also and one government advocate. Yes, you can proceed, or we will wait for the PP. You have come for quashing of the FIR.
Yes, Ladyship.
We can start.
Ladyship, in this case, there are 3 accused persons. And then the respondent number 2 is the complainant. Respondent number 3 is the alleged victim. Ladyship, in this case, the offenses of section 140, subsection 2, kidnapping for ransom.
Kidnapping for ransom.
Yes,
And 3-5 is common intention.
yes, no, Ladyship. Ladyship, in this case, the
Yes.
petitioner number 3,
Acha, let me go through the FIR then.
yes, that can be seen at page 18, relevant portion
Charge sheet
type
is
of
submitted, right?
charge sheet is,
And the proceeding is on,
trial is yet to commence in this case,
yet to commence.
yet to commence.
Charges are framed.
Yes,
Charges are framed.
yes.
Let me see.
Page 22.
Hmm,
May I read?
yes.
Page 22. To officer in charge, Kubota Outpost, Newland, subject FIR. With reference to the subjected cited above, we the Lotovi Village Council are obliged to bring forth the grievance to your esteemed office that Sir Mr. Salman, son of Chora, a resident of our village, has been kidnapped by 4 unknown miscreants who happened to come from white Alto car around 4 to 5 p.m. on 12th of August 2024. And to our utmost shock, the miscreants had demanded a ransom of rupees 2 lakhs, which is to be delivered at Gauhati Junction at 8 a.m. That is 13/8/2024. The village council thereof requests your interference to this matter as early as possible. This is the FIR. Ladyship, in this case, the petition number 3 and the alleged victim, who is respondent number 3, their relatives.
Acha, what were the respondent number?
Respondent number 3, who is the alleged victim, the alleged victim.
Yes, he is appearing for 3,
2 and 3.
2 and 3, yes.
2 is the complainant, 3 is the alleged victim. There are 2 separate entities. And then the petition number 3 and then the alleged victim, who is the respondent number 3, are relatives. What happened in this case is that the petition number 3 has lended an amount of rupees 2 lakhs to the respondent number 3 on different occasions, being a relative. The petitioner number 3 was in dire need of financial money, so he requested the respondent number 3 to return back the said amount. On numerous occasions, he has demanded, requested, but then to no avail, there was no response. That is why petition number 3 had ordered petition number 1 and 2 to go and bring the petitioner respondent number 3 to the residence of petitioner number 3 to solve the dispute. Subsequently, the petitioner number 1 and 2, on the directives of the petition number 3, went to the place of respondent number 3, and then he was picked up from his home, and then he was brought to the house of petition number 3. Thereafter, they have decided to settle the issue amicably, and then the respondent number 3 also decided to return back the amount. And then through his phone, the petition number 3 had called up the parents of the respondent number 3 to arrange the money and hand it over in the next day. Subsequently, they were called to come and receive the aforesaid amount on the next day, that is 13th. So early morning, when the petition number 1 and 2 went to receive the money, the law enforcing agency was there, and then they were apprehended. Now in this case,
This is the way that one should recover
Yes.
the money.
yes,
There are other
that's it.
ways,
Yes,
legal ways.
yes,
And have you entered into a settlement?
yes, that is there. Ladyship. On that basis only, we have filed this quashing petition. Ladyship, in this case, the case is purely of financial nature.
The Supreme Court has said about the guidelines about
Yes,
quashing,
Yes.
like if it is a family dispute, if it is, of course, commercial thing is also involved.
Yes.
This is not exactly a commercial thing. You are supposed to get money, okay, fine.
yes.
But then there are
So
other
far as
things.
that part is continued, yes, I agree, Ladyship.
Yes.
But then
But then you are agreeable for the settlement.
Your Ladyship, since the parties have
agreed to settle the issue amicably. I have no objection. And they have entered into a compromise deed dated 24/8/2024.
Money was given, money was.
Money was never. We have decided not to take.
Achha,
Let-
show me the charge sheet.
Charge sheet is a page, starting from page 25.
Achha, here the petitioner's name is what? Momento, you have to, there are three petitioners.
Three petitioners, three accused persons in this case,
All three were charge sheeted.
charge sheeted. All
And
three were
the-
arrested.
Huh?
All three were arrested in this case.
And then bailed.
Yes,
They are outside now.
they are on bail. Ladyship, in this case, they were arrested on 13th of August 2024. And then in this case, the charge sheet was submitted on 27th of August. 14 days after the arrest, the charge sheet was filed. And only on 29th of August, 2 days after the charge sheet was filed, they entered into a compromise. The family members of the petitioners went and approached the complainant as well as the family members of the alleged victim. And then they decided to settle the issue, whereby the respondent number 2 and 3 has decided to forgive the acts done by the petitioners. That is how.
Now, in the compromise deed, where is the name of the victim? Victim is
Mr. Salman. Compromise
is
deed is at
Salman.
page 23.
Salman is the victim.
Victim.
And complainant is of course the village.
Yes,
Care-
constable. The alleged victim's parents went to inform
Yeah,
the
that-
village
that's
council
okay.
chairman. That is how he has filed the FIR, the village council chairman. Compromise deed is page 23. Tish.
Financial issues between the victim and the alleged accused, who are both relatives, and misunderstanding arose. PP is here. Yes, what do you say on this? No, but the offense actually, amicably settled is okay. But the offense, all offenses are not, cannot be settled. As you know, Supreme Court has said off and on. Now here, what had happened is he was supposed to get some money. And the complainant, and then the petitioners picked up. And then, and they got the money and now they want to settle. There are other ways to get the money. There are so many ways not to just kidnap someone and take the money after the parents visit.
Actually, if kidnapping section is involved in it,
What is, yes, under what section the FIR is, what do you say?
140 subsection 2. Kidnapping
Some-
offense. Yes,
Kidnapping
that section has been
some,
involved.
As well as common intention.
The ladyship, in that case, I think the issue is deeper than just.
Yes,
my
this is what is
transaction.
revolving.
I'm sorry that my colleague is handling the case, so I'm not very well versed with the case, but if that section is involved, ladyship sometime may be given and let also my learned colleague also may make a necessary submission in this regard after 1 week.
Ladyship, so far as that part is concerned, I have one judgment. Same similar facts, same section, which has been quashed by the Honorable Madras High Court for
Madras
your
High Court.
reference.
Okay, let me see. Now this is, you seriously want time or I can dispose it of today? First, of course, one thing is there'll be no use in going for trial because both of them have settled. That is, of course, one consideration that Honorable Supreme Court used to often on say. If there is no likelihood of any conviction or there is no purpose for continuation of the trial.
My problem is since I'm not well versed with the fact of the case,
Mhm.
so I may not be or just blindly. So just for a few days adjournment so that my learned friend, my learned colleague who's handling the case may, or at least we can make necessary reference.
Okay, fine, then let me take it up day after tomorrow,
Oh, yes.
Thursday. Thursday, and then tell him, give him the brief, perhaps he has it,
Yes.
as prayed for by Mr.
K. Angami.
K. Angami, the public prosecutor
Yes.
for the state of Nagaland. And as prayed for name, Mr. So-and-so, public prosecutor submits that the instant case is handled by one of his colleagues. And as such, he prays for some time, and the said colleague is not there is absent due to unavoidable circumstances. And as such, he has prayed for some time. Prayer is allowed. List the matter on day after tomorrow. What is the date? 17. No, day after tomorrow is this is July, right? Yes, 17. List the matter on 17th of July, 2025. You wait for 2 days. Let's see what he says.
Flush
I'll take your judgment. I'll again we'll see it on Thursday.
For motion, item number 15.
Counsel is there. Counsel is not there. Acha, he's there. Yes. Who is there? The Union of India. You can take this. Oh no, the state of Nagaland. Government advocate is there. Your government advocate. Yeah, yes, this matter is there. Item number 15. You are public prosecutor or government advocate?
Both.
Or both. Then
Yes.
you can see item number 15. This is for extension to comply with certain orders. You are
Yes.
there in the matter.
No, I'm not here.
Call the respective government advocate who is
Yes.
dealing with this matter.
Leadership is.
We'll take it up after some time. Because there a prayer is made to extend the time to comply with the order.
Bless you.
Okay. Call the respective advocate.
For orders, item numbers 5 to 7.
There is again a delay of some days.
Yes.
Why has it come up for all this? Respondent number 2 and 3 are struck off.
Your Honor.
May I please, my lady?
Yes, you are
My
there.
lady, yes, yes. My lady, as per last order dated 3/6/25, my lady, service was awaited upon respondent number 2.
2 and 3. But then
2
in
and
the
3.
note, it is written that they are struck off from the appeal.
We
Name-
have, okay.
In view of 8/4/2020, in view of 8/4/2025 order.
Okay.
Right. So respondent number 1 appears.
Yes, respondent number,
Acha. So today, now that the service is complete, I'll fix it up for admission hearing.
okay, okay, my lady.
This is for delay.
Delay, yes.
Acha, delay. Do you have any objection in condoning?
Lordship, yes.
You'll file written objection.
I am here on.
Otherwise, my lady, I have explained the delay in paragraph number 6 of the delay petition.
That I will go to, but then if he has prayer for,
In fact, I was informed by the principal counsel that he had a call last night that the counsel for the petitioner is going through some typhoid malaria, this thing, sickness. So if the matter can come up after.
you are not there on the board for respondent number 1.
Yes, and I'm appearing on the instruction.
Acha.
Yes, yeah.
Okay. They need to file some objection or orally also you can do it,
Yes.
right? So let me fix it up next week.
Yes.
Okay.
Okay, my lady.
8 of August.
8 of August will be too long. That is next month.
Okay, no.
Here only.
My lady,
admission is
if it is for IA, it can be fixed in the next week itself.
So for condonation.
Yes, sir.
You do it next
Yeah.
week. You have no objection.
Yes.
Proceed with the merit. Right.
Actually the principal counsel is also a now station lawyer. So matter has been fixed on 8. So if it can come up on 8, be grateful.
Mr. First, appearing for respondent number 1. Praised for some time. On the ground that the conducting counsel is out of station and indisposed.
Yes, sir.
The conducting counsel is indisposed and that he has instructions.
Actually, they have informed us that they will be not be able to take the matter. That's why the principal counsel is not here today. The petitioners, they've informed us.
Oh, that you have
Yes, sir.
informed them that you'll not be doing the matter so that.
Yes, sir.
No, my
anyway,
lady, it was in respect of that hearing matter, item number 12.
Oh, there was some misunderstanding. It's okay.
Yes.
Then indisposed, let's list the matter. Oh, but what did I say? In view of to object to the interlocutory application filed for condonation of delay of 500 something days, right? 487 days.
482 days, my lady.
82, yes, 482 days.
Yes.
The prayer is allowed. List this matter on this 22nd of July.
Okay, my lady.
22nd of July.
Yes.
In the eye, okay?
Yes.
It's
Deeply obliged.
So motion item number 15.
Yes.
Well, President Lordship, this I was filed Lordship, in compliance of the strict honorable court order, dated, 7/3/2025,
Mm.
passed in WPC, 6/2023 Lordship.
The order was to place him in some other place, to post him in some other
Lordship,
place,
Lordship,
and you are
Lordship.
saying that no vacancies are
Yes,
there.
yes, Lordship,
And so you need some more time.
Lordship.
Let's see what the respondent come and say,
Lordship,
right? So let the notice go today.
Lordship.
This application is filed under filed for extension of extension of the period for compliance of the honorable high, for compliance of the order dated 7/3/2025, passed by this honorable court in writ petition number 6 of 2023. By the said order dated 7/3/2025, this honorable court has directed the respondent authorities to appoint, no, not to appoint, to post the the respondent in some other place and to as a chokidar, right? Some other place.
Lordship,
Some other place, and further to regularize his service in the said post. The learned government advocate submits before this court that there is no vacancy available for posting the respondent as per the direction of this honorable court, and further submits that there is likelihood of a vacancy only on 28/2/2026. It's a
Lordship,
long period.
yes,
right.
Lordship, how Lordship, it's difficult to accommodate this year, Lordship.
Okay, we will decide on the next date. But then this is very long. A chokidar post is not available in any other place.
Our Lordship, I mean, from that this year, Lordship, there will be no vacancy.
Okay.
It will be
And get
available
proper
in the next year,
instructions.
Lordship.
Because chokidar, according this court said that anywhere, any place you can appoint. And it is very unusual that there will be no post of chokidar in some other place. Get the proper instruction, right, on the next date.
Lordship,
And so what did I say? 22/8 to 2026, and as such, she prays that the extension of 1 year may be granted by this honorable court for compliance of the order dated 7/3/2025. Issue notice to the respondent. But what respondent will say in this matter? You cannot say. Issue notice, okay, issue notice to respondent. Returnable within 2 weeks. The petitioner to take, that line you write, so service of notice. And so by registered post and all. And on the, para, on the next date, the learned government advocate would place proper instruction as to whether there is no post of Chowkidar in any other place. As stated in the I, which is unusual in the consideration of this court. List this matter after 2 weeks.
I would
Get
like
the proper instruction.
Lordship.
This is not done.
For hearing, item number 8.
Last.
Remember the petitioner is Assam Rifle
Hmm.
support.
You'll do this matter today? Ready with the hearing?
Malo?
Ready with the hearing?
Yes, ma'am.
Yes. The other party is there?
Average.
This is item 8, right?
Right.
Item 8. Who is for the Union of India? You are. And there are private respondents also, I think?
No private respondents, Lordship.
No,
Huh?
No private respondents.
no problem.
No, in the cause list, it's showing 2 others. This is, 1 second, let me,
Put the council about
oh, okay,
yes.
1 second, and let me take out the writ.
Earlier, we were directed to submit written. Submit.
Hmm.
My learned friend has filed long time back.
Hmm.
So I am submitting only to the.
Yes, we shall define. Still someone.
The issue is that my lord,
We
my,
will go to the written submission later. Let me know the facts.
yes,
Huh,
yes.
okay. The writ petition, what are you challenging? Assam Rifles rules? No, no. Termination of service. Okay.
My lord.
Hmm. Yes.
So page 4 of my writ petition,
Yes.
he was enrolled in 23rd Assam Rifle in the rank of Rifleman General Duty on 19/9/2007.
Where are you showing?
Para 2
Hmm.
of my writ petition with regimental
He was
number.
enlisted.
Yes, enrolled, they call it, I
Hmm.
put it as enlisted, otherwise they take it as enrolled. Regimental number G501372-3.
Hmm. So he has also served for 8 years.
Yes. At that point of time, what happened is this impugn warning letter.
Warning letter.
Yes, 10/5 of 2015.
Where is that warning letter? 10/5.
Yes,
Some adverse comments.
my lord. that is page 15, Annex 1. May I read out, my lord?
1 second.
You were enrolled in Assam Rifles starting that on 19 September 2007. Since then, in your service of 8 years, 5 months and 22 days, you have incurred 3 entries in your dossier. The details of the offenses are as under. Serial number A, Assam Rifle Act, Section 26B. Date of offense, 1 October 2011. Statement of offenses without sufficient cause overstaying leave granted to him. For that, he has been punished 28 days, rigorous imprisonment in forced custody on 26 September 2014. Then B is Assam Rifle Act, Section 26A. Date of offenses 27 February 2015, absenting without leave. Punishment 7 days arrived on 3rd March of 2015. Then interesting is C may be seen, my lord.
Yes.
It appears that he was punished on 3rd March 2015 for offense on 27 February 2015. In the have imputed C, Assam Rifle Act, Section 35, that is intoxication. This is 2nd March, my lord. 27 February, 1 punishment.
Are I in force for custody
Yes,
on 3rd of March?
yes.
2nd of March, he was
just
found
see that
again.
if he was guilty on 27 February, on 2nd March, if it was tried on 3rd March, would have been given the punishment together. So this is what I am trying to see.
No, I mean, it is after 5-7 days, right?
Yes,
27?
February 27, 28.
Oh, February is again,
Yes, 28 days.
28 days.
Yes.
So immediately after 3 days.
Yes, interesting. That is what I'm trying to say. I'm
And
not
what
trying to
about,
impute anything.
Acha, what is RI in force custody? Just let me know
That
what
is
is
in
this.
their Assam Rifle custody.
They are in that Assam Rifles
Yes, they have their own-
custody room or something.
Yes,
And this is, you see, 7 days
all right,
RI in force custody on 3rd of March.
my lord.
So 3rd of March, this punishment was given
Yes,
for 7 days RI
my lord.
in force custody. And 2nd of March, he was found in an intoxicated
My lord.
position.
Yes. And for that, they have held another proceeding on 11 March.
Yes, 11 March, he was
So
again.
if
given.
this take it to be fact,
Mm.
it could have been tried on the 3rd of March. This is what I'm not imputing anything,
No, it
but
tried, see, on 7, this RI in force on 3rd of March,
my lord,
there has to be some proceeding perhaps before.
there should be.
Huh.
there
So
should be.
the proceeding was on and RI was given on 3rd of March.
My lord.
2nd of March, he was again found intoxicated. How can they
That is
include?
one day ahead of the
Huh.
proceeding.
But then the proceedings that was initiated
My lord,
after 27
my
February,
lord,
perhaps will not
that is
again.
what I am saying, that just say that I have committed 1 to 3 offenses.
Mm. Yes.
It could have been tried on the same day.
This, in excess is referring to this warning of
It's warning only, yes,
Warning.
yes. But warning is their own document,
Oh, this is
not my,
warning only.
yes, not my document.
So, Lordship, I can refer to para 2, and to para 2 of the warning.
So it is
No,
evident
what he
from,
wants to say is the punishment that was given for the 2nd offense. I mean, the.
3rd offense, yes.
It could have been
Yes.
included in the 2nd only. Warning for his dismissal. Then.
That is what I just want to project to your lordship. See the way the.
Your conduct
person-
has not improved. You are hereby warned to be more careful in your conduct. If you incur a fourth reading, then action may be taken to discharge you from service.
My lord,
Okay, then,
here, what I'm trying to critique is no material, no document except this piece of description.
hmm?
There is nothing to show that this, how it was. These punishment are not supported by any proceeding, any document,
Punishment is not supported by?
any of the proceeding.
Hmm.
It should be supported by proceedings for any show cause or for anyone. That is what I'm trying to say.
This is warning, then? what
Yes.
happened?
Then annexure 2.
Huh.
This is the show cause. Saying you are enrolled. This is 5th September 2015. You are enrolled as such and such, saying thereafter in your service of 7 years, 11 months and 40 days, as on 3rd September 2015, you have incurred 4 rate in
Oh, again,
increase.
fourth rating also you got.
Yes,
Intoxication again.
yes.
Then it is clear from above that you, in spite of having been warned.
So offenses, so D comes intoxication.
Hmm.
That is addition to the other first 3.
You were already warned earlier
Malo,
that if you get a fourth ring, you can be discharged.
that is
And
what
you
I,
got a
yes,
fourth ring.
yes.
Huh.
And it is interesting. In the proceeding, there was not even a single medical person about these 2 intoxication. How do you presume intoxication? 4th rate entry was what happened. On that particular day, he was on duty. So
Okay, so
suddenly,
we'll go to the report, inquiry report. Then what happened?
my lord, inquiry report did nothing to even till today.
Hmm?
About this proceeding, B, C, in D. Inquiry report did not furnish to me. Even after I demand under the RDA not furnished. Even before this court, you have not furnished that one. That is the interesting part.
Okay.
First proceeding is enclosed in the affidavit in opposition. So what I'm trying to say is about that this particular the 1, 2, 3, 4 show cause should be accompanied with the supporting documents.
Articles of charge and all, everything?
Yes. Nothing is there. Except
Okay,
this show cause notice,
Okay, show me the other things.
my lord. So what happened? The petitioner is illiterate.
Okay.
So he took the assistance of his brother.
What
By-
is the post? Recto GD means?
Pardon?
What the post he was holding? Rect.
Rifleman,
Rect.
general duty. General duty are the people who carry the rifle.
Acha.
In-
General duty.
Yes,
And what is rect? RECT?
recruit.
Recruit.
My lord, which one?
No, he's enrolled as Assam Rifles as rect. RECT means what?
Recruit.
Recruit.
Recruit. RACRUIT.
Okay. Then,
Then through WhatsApp, he got the assistance of his brother in he wrote this annexure 3, page 70.
apology.
Yes. May I read out?
Yes.
Prayer for apology. That is the English. So your lordship understand what is the standard? Sir, most humble and respectfully, I would like to state the above cited subject in the state embarrassment for my own self-deed. That is, that I had failed to
perform my duty
perform my duties sincerely as per the services rule during the past day of my services. Therefore, I would like to beg your kind authority to kindly accept my apology in consider me to continue my services. In for it, which I have your kind consideration, I will perform my duty as per the service norms, as in the interest of my superior. That is his
his
Oh.
reply to the show cause notice.
my lord.
This is the reply to his show
My
cause
lord,
notice.
my lord.
This is dated what?
Dated years
50, no, what is this date? Can't even read the date properly. 23.
Paratri I've stated, but date is not given. Paratri of my petition, the petitioner submitted application dated nil on the subject prayer for apology to the DIG, headquarters 7th sector, Assam Rifle, CO99 ABU to service. It is stated that petitioner being illiterate in being only class 8 pass, his application was written and submitted with the help of his elder brother.
Dated nil. Then
My lord. Then comes the discharge order. My lord.
this is the impugn order.
Yes. I have impugned both the show cause also.
At 4th October 2015.
My lord, may I read out? Whereas it is considered that conduct of numbers such and such, General Duty, Kyolo Pongbi of 23rd Assam Rifle, which has led him to getting forward in increase, is such as to render his further retention in the public service undesirable. That is the word, my lord. Being incorrigible.
Not been able to be reformed.
Yes.
Whereas so and so
Not
was afforded
being
an opportunity.
Incorrigible, my lord, I am emphasizing on that. Incorrigible, whether it comes under the provision of the Act in rules or not. Incorrigible offender in having failed to show improvement during his service, in where such and such was afforded an opportunity to show cause against the proposed action by such and such, in where such and such has submitted this reply by letter dated 12 September.
Achha, that is
My
12
lord.
September.
Yes. 2015, the same was considered in terms of ROI 1 of 2004 and was found unsatisfactory by the competent authority. 4. Total qualifying service of the individual up to 8 October 2015 is 7 years, 10 months, and 11 days after deducting non-qualifying service. Now, therefore, being the competent authority under Section 11, Clause 2 of Assam Rifle Act of 2006, and in exercise of the powers conferred on me under Assam Rifle Rule 17 and 25 of Assam Rifles Rules of 2010, read with Section 11(2) Assam Rifles Act 2006 in Para 5 of ROI 2004. The undersigned hereby discharge the said number such and such from the Assam Rifle being incorrigible offender. Soldier with effect from 4th October 2015 forenoon from the service with benefit as admissible under CC's pension rule 72. It will not be qualified for pension under 72 since not 10 years. So that is the discharge order. So after this, the petitioner applied under RTI through his counsel. That is Annexure 5. Sir, kindly furnish me authenticated copies of the following in respect of my client such and such. Discharge order, 4th October 2015. That is for ready reference. 1. Appointment letter. 2. Detailed documents of the disciplinary action taken as per the report. 3. Notices if any issued by the authority. 4. Reply to the notice if any. 5. Complete case forwarded to the secretary headquarters along with the notice in reply for approval. 6. All documents sent to the Directorate Record Branch, UPAO, for final settlement of individual running ledger account. Such and such. Kindly send the reply information to the undersigned address such and such.
Then
You see that
there is another RTA.
no, yes, he denied it.
Hmm? Hmm.
Yes, that is why. This is to the appellate authority.
Hmm.
The same. Then this was also not furnished.
Then he made an appeal.
Yes. Page 21.
Page 23, in fact, the reply came.
Yes. So they have not furnished sample word is that.
They are exempted to furnish those.
Yes. If you want to furnish, that is all right. That is up to them to furnish or not to furnish. Because as per the, under the constitution, if somebody have to be given a show cause, it goes without saying that the document should be accompanied in the show cause itself.
Hmm.
So furnish, not furnishing will not go against me. It should be the other way around.
Then the health issues.
My lord,
We have annexed something on the health issue.
this was about his wife.
Wives.
Yes, that is punishment in serial A, my lord.
Oh, that
Yes,
unauthorized absence.
yes. So that time what happens? The wife was pregnant, so
Hmm.
he took leave. And
You have annexed one order here.
yes, I'll come to that at the time of my written submission.
Okay.
What
Then,
happened is that
Hmm.
his wife gave a premature child in the hospital, who died right after the birth. There was no one to look after the wife. He was ailing.
Hmm.
He was absent. Accordingly, he produced all these documents.
Hmm.
Then he was punished. Of course, my absence period was regularized by including extraordinary whatever leave was due to me, due to the person.
That was accommodated.
Yes. So to that extent, I have no dispute.
The first one. The first reading.
My lord, he was absent.
Hmm.
That is an admitted position.
But he had a reason.
Yes.
Hmm.
So,
And that was taken care of.
my lord, yes.
Hmm.
With punishment,
With punishment.
my lord. Anyway, whatever it is an admitted position that I was absent. I overstayed leave because of the given reason. For that,
Hmm.
there was a proper proceeding, which is the only document included in the affidavit in opposition.
Okay, then,
So what I am challenging is para 12.
of your petition.
Yes. Article 311, it comes into rescue or
Hmm.
imposing any punishment. It should be, there should be a procedure.
Hmm.
That is what I'm trying to say. There is a decided case of this Honorable Court, para 50. Union of India versus Molindra Chowdhury. This High Court.
That
1990.
one you have annexed.
Yes.
Hmm.
I've given para 9,
Hmm. Hmm,
which
para
is,
nine.
yes.
It is a declared concept of law. Then,
So I am praying for warning leader, number one.
hmm,
Challenge. I am challenging beginning from warning.
challenging?
What? Warning leader.
Yes.
And two, show cause.
Huh.
Show cause without any material.
Hmm.
So also is the discharge.
Hmm. So three things.
Yes.
Let me see your prayer.
Page 13.
Yes, yes. Okay. Hmm. Yes, then,
Then may I take your lordship to my submission?
Hmm.
Because I refer it to the affidavit in opposition of my learned friend
Hmm.
as well as my reply.
Now you refer to your written submission.
Madam,
Yes.
so para 1,
Hmm.
the warning letter.
Hmm. Para one of your submission.
Yes,
Ah.
it is without any documents. And it is against the mandated Assam Rifle rules of 2020.
Yes.
16 to 20 of subsection 2.
Hmm.
It shall so inform him together with all reports. That is the whole thing. With all reports. It verse to him, and shall be called upon to submit in writing his explanation defense.
This has not been done.
This is the rule.
Yes.
Your lordship.
Assam Rifles rules.
Yes, my lord. So, rule 20,
Hmm.
no.
Yes. Termination.
Termination of service of person other than officer on account of misconduct.
But then sub-rule one will not apply to you
No,
because you have been convicted.
comes in after considering the reports and the misconduct of the person concerned. The authority as specified in Rule 17, that is the authority who can dismiss somebody, is satisfied that the trial of such a person by force court is inexpedient.
Hmm.
Under what situation it is inexpedient?
Hmm.
It is not there or impracticable. That is not the case here.
Hmm.
But it's of the opinion that his further detention in the service is undesirable.
Hmm.
It shall so inform him together with all reports adverse to him. That is what I'm trying to. It is just like disciplinary proceeding
Hmm.
in the department. You cannot just give a sheet and say that you are such and such. No. Then, para one of one.
Hmm. Yes, then what? Para?
1.1.
Acha.
I'm going by what A.
Hmm.
The first punishment was under section 26B.
Act.
Act is here 26. Who overstaying late, OSL. that is
26B.
Madam,
Hmm.
without sufficient cause, overstay leave granted to him.
Hmm.
Punishment was awarded for RI for 28 days in forced custody, that is Annexure A, page 22 to 25 of the opposition manual, not mine. It came up in the opposition.
It's 1, 2, 3. Yes. Annexure A, page.
Page 22 to 25.
Yes, I got it. Without
So
sufficient
I may be
cause.
allowed to show this. This was proper proceeding. That is what I'm trying to show to your lordship. A, yes, there was proceeding.
Mhm.
Yes.
Hmm.
As far as this part,
Mhm.
yes, there was proceeding. For that,
Proper proceeding.
yes.
Yes.
So what happened is this, I may be allowed to take your lordship. Form for use. It's summary proceeding
Hmm.
of under officer in other enrolled person. I come under enrolled persons.
Hmm.
Under section 62. What is 62?
82 or 62?
62.
Ah.
It is minor punishment, my lord. 62 is all minor punishment.
62.
Yes, that
This
is
is.
with your lordship.
Mhm.
Section 62. Punishment starts from chapter 5,
Hmm.
section 57.
Acha, 62 is minor punishment.
Minor,
But that
this
is
is,
62 or
yes,
82.
62, my lord. Others are
Hmm.
major punishment. Starting from 57.
Hmm.
So this is called summary assumed proceeding, which can be conducted by the commandant himself, not like other
So
courts.
here, of course, reasons given having been granted leave of absence from 3rd September to 30th September fail without sufficient cause to rejoin.
My lord,
Expiry of leave till he voluntarily reported on 29th of April after so many years.
my lord, yes. Thereby over staying
576.
leave for 577 days,
577.
my lord.
So more than a year, more than almost 1.5 years.
My lord.
Hmm.
So what happened is this, here, the plea is guilty.
Wait, a former means how much was it? So arrive for 28 days.
Yes, then there were two witnesses against me. That is, a gentleman by the name Subidar
Hmm.
T.B. Gopal Singh.
Hmm.
Then C.H.M. Harsing Puru.
The accused declined to cross-examine the witness and you did not cross-examine, neither you had,
I have given my statement. Yes.
then,
Then this part,
Hmm.
based on order of Commandant Sergeant Sarge, page 45 to 52
where,
of the
wait,
opposition.
you are going to the second point.
No, continuing this
Ah,
first one. They furnish it in different
Hmm.
batches. That is why 22 to 25 is about the proceedings. What I'm trying to see is this is under 62. That is what I'm trying to see.
So you want to place page 45?
44,
40.
yes, 44 to
Not 40, 44, 45.
yes, 45 to 52. This is
Uh-huh.
continuation, but the document is
Hmm.
arranged in different batches. That is why. 25th February 2014, order of the commandant and the court of inquiry. Proceeding held in such and such
Hmm.
about the such and such who proceeded on 28 days early with effect from 3rd September 2011 to 30th September 2011, failed to rejoin his duty on expiry of said leave till he voluntarily reported on 29
What is the
April.
difference between this and the other one? This is offense report.
This is by the commandant.
Hmm. Absence of so-and-so will be regularized
Same.
and debited
Yes.
from his leave account. Okay.
Thereby overstaying 577 days. Absence period of 575 days with effect from such and such to such and such be regularized in debited from his leave account.
And a disciplinary action was also initiated. It's on the right hand side.
My lord. Then,
Hmm.
as per this, there was a proceeding. Court of inquiry,
Where? Witness number one.
page 40.
Okay.
My lord, page 46.
Hmm.
This is how,
Court of inquiry proceeded.
yes.
Hmm.
For the purpose of investigating same offense, overstaying leave of 577 days. Presiding over officer is Captain Sergeant such,
Hmm.
members 1, 2 gentlemen
Hmm.
of the battalion.
Then witness.
Yes, my lord. So I may be allowed to come to that. So witness number 1 is the petitioner.
Hmm.
Para 2, such and such proceeded on 28 days early with effect from such and such to such and such. My wife was pregnant in not keeping well, because of which I was disturbed in failed to return duty on expiry of the said leave. And informed neither the battalion nor my company of the same. Admitted. Thereafter, my wife had the premature delivery in the 8th month of pregnancy on 28 April 2012. And the newborn expired within a few hours of delivery. My wife was discharged from the hospital on 1st May 2012. However, did not recover from her illness. It required continuous medical attention and care at home. Since there is no one in my family, I had no option but to remain at home to look after my ailing wife. I voluntarily returned on such and such after a gap of 577 days. That's an admitted fact. Question by the court. Question 1. Number such and such punished earlier? It appears yes. Question 2. Did such and such requested for any extension of leave? No. 3. Have you any correspondence with anyone in the battalion after being OSL, that is overstaying leave? No. Do you have any medical document in support of the statement given by you that your wife was ill in a stillbirth on 28 April 2012? Yes, I have all the medical documents in support of my statement given by me. I hereby produce a copy of the same. Bracket. The court examined the copy of the medical documents in are attached as Exhibit A. Question 5. Were you arrested or wanted by security force? Were involved in any illegal activity during the period of being OSL? No. I was not arrested or wanted by security forces involved in any illegal activity during the period of being OSL. I hereby produce a copy of the police verification certificate later from STO and hit your lordship, whether you are familiar or not, it is only in Nagaland.
Gaubura is there.
My,
Other places.
my native place to certify my non-involvement in illegal activities. The court examined the copy of the documents in are attached as Exhibit B. So the witness against me, that is for the department, is page 40.
He in reply to the first question had said that he was punished on 2 earlier occasions too.
My lord, it doesn't speak about anything, but because there is no record as seen. Anyway, it appears that it admitted that I was.
He was kind of. Okay, then witness number 2.
Number 2, page 48. This is CHM, Company Havaldar Major, Harburu Singh.
Yes.
I such and such performing duty of CHM E Company, number such and such, proceeded on 28 days EL with effect from such and such on 11 October 2011, number such and such, failed to return to the on expiry of his leave.
It's okay, I've read. Only the answer to the 4th question, the conduct of the individual is satisfactory. However, he is a habitual offender.
My lord. It is-
Otherwise, he says that he had taken leave for so and so days, he did not rejoin and he joined after so many years.
My lord,
And then 577 days delay.
my lord,
So he supported the prosecution.
my lord,
Therefore, Then witness number 3 is Gopal Singh.
yes.
He also
Subhedar.
said the same, he proceeded on leave. And then,
My lord, he supported my version of the premature delivery of the
yes,
child.
he supported the region.
Yes.
I immediately, okay, had failed to join. I immediately informed regarding the same. The individual voluntarily rejoined after a gap of so and so, informed me that his wife was pregnant.
My lord.
Okay.
Then finding of this is court of inquiry, the authority for punishment is with the commandant. Inquiry is conducted by these three gentlemen.
Inquiry is conducted by this court.
Court of inquiry,
Court of inquiry.
captain in Subedar, another Subedar.
Mhm.
So what is your finding is page 50.
Mhm.
Mr. Such and such proceeded on such and such saying, however, the individual failed to return duty after the expiry of his leave and did not inform anyone regarding the same statement.
His wife was
includes-
pregnant.
Yes. His wife was pregnant and not giving well, because of which he was disturbed and failed to return duty on expiry of the leave. He also told me that his wife had a premature delivery in the 8th month of pregnancy on 28 April 2012 in the new born expired within a few hours of delivery. Thereafter, his wife was discharged from the hospital on 1st May 2012. However, he did not recover from her illness and required continuous medical attention in care at home. Since there was no one in his family, he had no option but to remain at home to look after his ailing wife. Statement 1 to 3.
He said that he is an habitual offender, but he is not involved in any illegal activity.
No.
Then what is, this is the findings, then.
My
opinion
lord,
of the
that part,
court.
this is the proceeding of the inquiry, that is like in the departmental inquiry.
These are the findings, and then what is the opinion?
28 December 2013.
Where?
This court of inquiry is like departmental inquiry.
No, where did you get the date? 20?
Page 46.
Hmm.
On the day of 28 December 2013.
28 December. Oh,
My lord. Then based on these proceedings, page 45
45?
is by the competent authority to pass order against me. 45.
There is an opinion of the court also before that.
That is what 45, my lord.
No, 51. What is page 51?
51 is finding of the court of inquiry,
This is the-
departmental proceeding.
That is finding it as page 50. Opinion of the court.
Yes,
The individual is to be blamed
my
for
lord.
the irresponsible behavior, and it is recommended a necessary disciplinary action be initiated against him.
My lord.
Then 45.
This is all the proceeding of the court of inquiry.
Yes.
That is captain,
Hmm.
another superior, another superior.
Yes, okay.
So this finding, the punishment comes at 45. That is by the
Commandant.
competent authority.
Hmm. So the commandant order is that it may be regularized and debited towards his leave account.
My lord.
Then, okay. Then the first part is gone. Then, then you'll go to your written submission.
My lord. by para 1.1, that is what I've submitted now. Then para 2,
Page 4.
yes. Para 2 is there was a compliance of the proceeding. Except para 1.2 is as far as punishment given in Shopus stated that inside annexure 2, there was no court of inquiry. Because earlier, as your lordship is clear that there was a court of inquiry. There was no court of inquiry.
As for now, you're going to show cause notice. There was no court of inquiry.
No, that is what I'm trying to submit, man. As far as serial B, the offense report awarded by Colonel for absenting himself without leave from,
Where is that
Come.
offense report by Tarun?
that is page 26.
Of your
29
repetition,
of the affidavit opposition,
not repetition. You have written repetition here. Oh, no, affidavit in opposition.
my lord.
26. Yes.
26.
This is in respect of second number of a reading.
My lord. Serial number B. After show goes in
Yes, page number 26.
26 is for summary proceeding under 62. The offense is on 27 February. My lord.
He absented himself
Yes,
without
at
leave.
field. Yes, on 25th.
In field
Yes, in the field.
from 1900 hours to 22 for 2 hours 40 minutes.
My lord, that is what I was trying
3
to.
hours.
Yes.
So
Mhm.
to suffer RI
Guilty.
for 7 days in court
Yes.
custody. Okay.
As your lordship has pointed out, 2 hours. But the timing doesn't make any difference. I want to agree to that. Whether somebody is have done certain mischief or not, that will be the determining factor. Hours, but
So what
2
is
hours.
the explanation
Yes.
of your in respect of this?
There was no proceeding, that is what I think.
No proceeding. What about page 27, recording of proceeding?
That is what they are trying to say.
Charges were explained to him.
Yes.
Hearing of
In,
witnesses were
they
done.
are saying that prosecution witnesses, Mr.
Decline.
Gentleman Lembo
Decline.
in the Turkey, dear prosecution witness, my lord.
Hmm.
They've shown it in the column, but there is no statement, no
No
evidence.
statement.
No. Only A, as your lordship has noted. The court of inquiry, my statement, the statement against me, all are there. As far as B, C, in D, no.
Acha, let me see B. There are, although they are arrayed as witness, but no statement.
No. We are showing 2 witnesses, like in the earlier.
For last column. Whether accused cross-examined, whether accused cross-examined the witness or declined to cross-examine Only state yes or decline before each witness is.
Decline,
So
decline.
So he has declined to cross-examine.
My lord, there was no proceeding.
No, I mean, maybe there are statements.
No,
I'll come back to him.
yes. If they have, in the affidavit in opposition interest, they come up with punishment A.
Hmm.
In the proceeding or show cause or even after my demand, it was not furnished to us. Even after the writ petition, they came up with the documents. Only in the case of A, that is my absence. There was a court of inquiry.
Hmm.
The proceeding is supported, even though at the time of punishment, it was not furnished to me. So this B, they are trying to say that two gentlemen were taken as prosecution witness. No statement.
And Lordship, I say this indeed. Witnesses were heard orally by the commandant.
Where?
Page 27,
Yes.
page 27 at para 4 in the column. Date on which the witness was heard orally by the commandant.
Was heard orally.
Yes, sir.
Dates on which the witness was heard orally by commandant.
Yes.
So 3rd of March, they were heard orally.
Orally.
And then your client did not cross-examine.
What I'm saying is this.
Hmm.
If they are saying that they have examined illegally,
Hmm.
it should be in my presence.
Hmm.
And it should be supported with that document. Not by this statement. Let them support it with their evidence.
Okay.
Or
fine. What you
statement.
say is the document is not there.
My lord.
Then what is the punishment? Who inflicted who commandant again?
My lord. He is competent under section 62, since it is minor punishment. That is possible.
Then where is the punishment given?
It is given to be tried summarily. So we could have tried summarily. That is possible.
Summary proceeding only. Then-
Yes. So the commandant is competent for that.
So he was given rigorous imprisonment for 7 days.
My lord, as per their
Yes.
documents.
Then
Then she comes from page 30.
what about your written submission?
Yes.
So B is over.
Yes.
Hmm.
Page 30 to 34.
Of the AO.
Yes.
Hmm.
30 to 34.
Yes. So this is intoxication.
Yes.
Hmm. Then
So also here also it is given
hmm.
name of witnesses.
2.
Yes. He is a Sopidar, not from Mitigan. Another also is Havaldar, not from Mitigan. Not from Mitigan.
Not from medical.
Yes.
Huh.
How do you prove somebody is drunk? Intoxicated.
You don't need medical officers always to find someone as intoxicated.
The fourth punishment was for the intoxication.
No, as far as C is concerned, what do you say? Here there are two witnesses and they are said to
No,
have
no,
been-
no statement is furnished
But then, okay.
before your lordship.
Orally they were heard, they said,
It
and then the
was
punishment is inflicted.
My
Then,
lord, simple is this, if somebody statement, witness were taken, it has to be before your lordship. Without that, even if they have not furnished it to me, it is not even before the law. That is 2nd March.
then this proceeding was done on 11th of March
Yes,
and the offense was of 2nd of March. Then, and the punishment was inflicted on 13th of
as per
April.
their column, yes,
13th of April.
yes.
Okay. Then
Then third one,
third one is gone, now fourth one,
fourth one, yes, page 35.
35. Mhm. 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 Intoxicated. Now these are again not doctors, we know.
Yes.
Then-
It fell on 16 June 2015, such and such telephone duty, its company rear was intoxicated.
Where are you reading from?
Page 35,
Mhm.
offense.
Mhm. What does it mean on 16th of June 2015, when on telephone duty,
He
and
was, yes,
company was intoxicated?
that is what they are trying to allege.
What at when on telephone duty at company rear? What does it mean? So he was on duty of receiving and answering telephone calls.
My lord, attending to the telephone duty, my lord.
Hmm. Thereafter, what do you want to say?
My lord, what happened, this allegation is this,
Hmm.
when he was on telephone duty, he was directed to send a particular truck
Hmm.
to a company. So in order to, it should be entered in the register to whom it is been transferred. That was the only reason.
That he did not do.
He did,
Mhm.
but the gentleman took it as a
Hmm.
insubordination. That is why this particular incident took place. It was not that he was not performing his duty.
Not entering in the register, where do I find this?
My lord, what I'm saying is,
Acha.
when he
Okay.
was,
Then,
my writ petition, page 7 may be seen.
your repetition,
Yes,
page.
page 7. This is quite interesting, my lord.
Mhm.
And there is no reply to this.
No reply by the,
By the
which one you said? In your writ petition, which paragraph?
page 7, para 6,
Page 7, paragraph 6, okay.
point 3.
Point 3, okay.
With regard to punishment D,
D, okay.
yes, the petitioner in the year 2015, he was detailed for telephone duty at the unit between 20-30 hours to 22 hours. While attending his detail duty, he got a call from his superior directing to send 2 trucks of B company to motor transport in the of the unit. As such, the petitioner inquired as to whom he was speaking to to
And
record
to
he
record.
knew the person from whom he was getting the command. And the petitioner was informed that it was Major such and such speaking from motor transport. Accordingly, the petitioner directed the D company to send in report the said 2 trucks, which was complied with as commanded by such gentleman. However, after the said 2 trucks reported to motor transport, such and such came by a gypsy vehicle where the petitioner was attending his detailed duty, and even without any inquiry, not to speak of proceeding. As mandated, this is not mandated, as mandated.
Was again.
By the
awarded
law, the
punishment.
petitioner was again awarded another punishment for such and such. This is the attitude against that.
Acha, there is no reply to this.
No,
Let me see. Paragraph 6.3. There is a reply. The answering deponent states that statements of so-and-so are false and fabricated. Leveling allegation against Major Batania, the petitioner is trying to mislead the court by narrating false and concocted story to cover up this act of omission. Telephone duty. He was found in intoxicated state. As the petitioner had breached the discipline, hence he was marched up to so-and-so, wherein a tentative charge sheet was handed over. It's given everyone he was marched up to commandant demand. There is a reply. It's not that there is no reply. Then
that is normal duty for anybody. I may give a command to the subordinate to do a certain thing. Certainly, the duty personnel have to record a certain action being done or undone. That was the only issue. Submission para 1.4.
the fourth punishment was awarded again for intoxication when on telephone duty.
Yes.
Okay.
Yes.
Then the copies of
Then
the court of inquiry.
1.5, the copies of the inquiry conducted under the rules, that is 183 of Assembly rules, indeed. For his punishment was furnished in the respondent EI, not to the person.
But for the second, third, and fourth.
But for the second, third, and fourth punishment, the copies of the court of inquiry were never furnished as mandated under science act. In the petition.
Neither at the time of show cause notice. Okay.
Not even after demand, not even before your. That by June show cause stating that he had incurred such and such, directed to reply, the statement is such and such, it is stated that no documents in support of the show cause was furnished. Yes, the petitioner being illiterate, that is
Wait,
my
1 second.
apology, yes.
Wait. The
Prayer
what is-
for apology, your lordship has noted that.
No, this
Yes.
one. Show cause notice dated so-and-so, written by so-and-so, state incurred and directed to reply the notice within 30 days. It is stated no documents.
No, without any.
Documents were not given with show cause notice. Then he was an illiterate then.
That is why that the
Apology.
prayer for apology.
Without considering the petitioner's prayer for continuity of service. That too without any proceeding.
As being the word being incorrigible.
Incorrigible offense.
Yes.
Okay.
Under section 17, that is the competent authority for discharge.
Hmm.
I'm not questioning about.
He is a competent authority.
Yes.
Then
25 of Assam level, para 5 of record office instruction, 1 of 2004. So the discharge of petitioner being incorrigible offender under rule 17 in 25 is to play against the rule. That is rule 17, termination of service. It's who the grounds under which.
so misconduct, unsuitability, unsatisfactory progress, furnishing false, wrong information, physical unfitness on request. So these are the grounds under which termination can be granted,
That
can
is-
be,
that is
can be
under-
imposed.
Yes,
but
under the rule, not being
incorrigible.
incorrigible offender, which is outside the rule. And under rule 25, termination of service of enrolled person, that is the petitioner
petitioner.
comes under enrolled person.
Yeah. On grounds of unsuitability.
And enrolled person shall be furnished with the particulars of all matters, verse to him, no.
Nothing was given.
So for the established fact is that even after applying for the documents, for the disciplinary proceeding, new documents and information was furnished to the person. That is my anecdote. The so-called documents of proceeding was not furnished to the petitioner at the time of issuing the impugned show cause notice, even after RTA application. But the said documents of so-called proceeding were annexed in their affidavit in opposition, list 113, which was received on
Okay, this we have
11
gone through.
of 2022.
This we have gone. In the
The
union,
first time I came to know about this proceeding is has to be this particular thing.
in the AO.
Yes.
Then the Union of India judgment you have referred. Okay, 311 has to be complied with.
Yes.
That alterum partem was not given.
No. Then Molendra, that is dishonorable court judgment, para five.
This one I have seen, 311 has to be
Yes.
complied. Then again, Balwant Singh,
Yes. Para
red ink
15.
entries were recorded. To appreciate comparison of red ink entries recorded against so-and-so, referred to by learned government or in order. In case of the one, this was altered to function.
Then the Supreme Court Amarendra Kumar Pandit.
Acha, Balwant Singh, it is said that 3 charges of intoxication and 1 of overstaying can be considered in the serious offense. In your case, it is minor only,
Yes, the
no dispute,
number one, when it is under 62, is minor.
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 Then Amarendra, why you are referring? Red ink entries received.
Page 9 of my submission. That is the heading, my lord. May I read out?
No, I've read, it's okay. It is
Minor.
necessary that the order of discharge is speaking order. A single just set aside the discharge and remitted to the competent authority.
Annexing as running batch. One of this, I bracketed RB, running batch.
Which one?
This, Amarendra Singh,
Yes.
yes, decided such and such. Bracketed RB is my running batch to this, my written submission.
Okay.
My lord,
You have annexed those judgments.
my lord.
Check.
So that is running batch.
No reasonable.
10-7, my lord.
What was done in the Amarendra Singh's case?
My lord,
It was sent to the competent authority.
this is also in connection with grade 8 entries. My lord.
Therefore, to do substantiate, the order of discharge is set aside.
My lord.
And the appellant is treated to have been in service till the time he could be said to have completed the qualifying service of grant of pension.
My lord.
You have not completed qualifying service, right?
No,
So no pension.
no, no.
I mean, till now.
Yes, yes. I understand your lordship.
Similarly, and then Rupesh
Yes.
Suryavanshi.
Paratan, similarly, in the present case in hand, I find that 2 charges against the delinquent official for intoxication and absence from duty without proper leave application. In my considered view, such charges cannot be.
Cannot be serious offenses. Okay,
No.
no dispute with that fact. Besides that, since the delinquent has already been punished, therefore discharge of service on same grounds amount to violation. Okay,
My lord.
okay. So he has already been punished, so no discharge. I feel that such violation of intoxication, not agree with the discharge. Okay. And then the order was quashed and to reinstate. What is Vijay Kumar?
Vijay Kumar,
Cannot be punished twice for the same offense.
yes. The union tried to see that the learning council responded submitted that the principle of the body of the Article 20 of the Constitution of India is not applicable where army personnel are involved, but I do not agree.
No,
that-
this will not be applicable on you. This is not punishment for the same offense. You have been found intoxicated twice.
Yes.
Once and again thereafter once. So this Article 20 will not come. It is not the same offense. The nature is same,
My
but the
lord,
offense is not same.
when somebody is punished under 62,
No.
Assam Rifle also 97 comes in.
Mm.
You cannot punish him for once somebody is punished under minor, under 62,
Mm.
somebody cannot be punished. That is under Section 97.
Hmm?
Assam Rifle Act, Section 97.
Assam Rifle Act,
Yes.
97.
97. This is as the same as 20.
Article 20.
Yes.
When any person subject to this act has been acquitted or convicted of an offense by the Assam Rifles Court or by criminal court or has been dealt with under section 60 or 64, 65, shall not be liable to try it again for the same offense. No, you are confusing with same offense and the same nature of offense. Same offense it cannot be, but nature is same, but offense is not same.
What I'm trying to say, when somebody is punished under
62.
he cannot be punished on the same issue. That is, on that basis, he cannot be discharged. That is what I'm trying to say.
Okay, that is
Yes.
your argument.
Yes,
Hmm.
I leave it up to your lordship.
Then
That is the rulings which I like. What I'm Para 9. The established facts are as follows. Creditor 1, Showcase was not accompanied with documents, even after demanding.
In spite of demand, he did
Yes.
not get.
Then it was only in the EI.
Only in AO you got.
Yes, ma'am.
All the said proceedings were under 62.
Yes,
Where a person is sentenced under 60, he shall not be liable to try again for the same offense.
so 97.
But then again, I'm not clear. Make me clear. It is
Madam,
not the same
what I'm trying
offense.
to say
What do you
is-
say? This is not the same offense.
Different offenses.
Separate offense, same
Separate
nature of offense, but not the same offense. So
Yes.
the 20 or 97 will not come.
First offense was
Fresh offense.
different
Madam,
offense.
what I'm trying to say.
Fresh offense,
Yes,
fresh offense.
1697 of Assam Rifle Act is the same protection as given in section two, article 22 of the Constitution.
For the same offense.
Yes,
It
no
is-
person shall be prosecuted in punished for the same offense more than once.
So
That is
it is
what
the
I'm
same.
saying.
He was found intoxicated twice.
On twice occasion.
My lord, take it. What I leave it up to your lords. One thing is that. See, whatever allegation they are making against me, it is their own imagination, not supported with any document.
Documents, that
No.
you have said. Then this is all?
Then, when somebody have been punished, see that the first punishment I accept all in two.
First
There was a
punishment, okay,
proceeding.
it was adjusted with your leave.
And rigorous imprisonment was also imposed, fine. I was guilty as charged. I accepted responsibility.
But not 2, 3, 4.
All the proceeding is before your lordship, supported with all the proceeding and documents. He did not. Not even before your lordship. That is what.
That's all?
Yes, much. better.
No, now let me hear CGLC, this.
Lordship, after filing up an affidavit in that session.
One second.
Yes,
Yes.
he has filed a short affidavit with reply only.
This is what he was referring to.
So that means he has got all the documents.
What he is saying is, as far as number 1 is concerned, okay, he is satisfied. But 2, 3, and 4, he's saying he did not get the documents and no documentary
That's right,
evidence.
Lordship, I have filed my affidavit in double session, so let me read this para two to D.
2,
From para two, let's.
2D,
From two to D, to D. From para two.
yes.
It's a set para, so short para. Page 2, Lordship, para two. That the brief of that in brief, the history of the British service report after enlisting in the organization may be stated as follows. 2A, the petitioner, so Koningkabe was enrolled in Assam Rifle on 19/9/2007. He was tried summarily on 4 occasions during his entire service for acts of omission on his part, and on being found guilty, he was awarded 4 red ink entries in his service dossier. 2A. Despite repeated counselings by the unit authorities, the rifleman did not show up any improvement in his conduct and proved himself to be irrecoverable defendants. His further retention in service was found to be detrimental to the discipline of the soldiers of the force. Therefore, action was initiated to terminate him, and he was discharged from service with effect on so-and-so. I'll go to 1. Remind 1, Lordship. 28 days rigorous imprisonment in Assam Rifle custody on 26/2/2014 under Section 2B of the Assam Rifle Act 2006 for the offense of without sufficient cause overstaying the leave granted to him. And then Roman 2, 7-day rigorous imprisonment in Assam Rifle custody on 3/3/2025 under Section 26A of the Assam Rifle Act 2006 for an offense of absenting himself without leave. Roman 3, 7-day rigorous imprisonment in Assam Rifle custody on 3/3/2015 under Section 335 of the Assam Rifle Act 2004, an offense of intoxication. 4, 28 days rigorous imprisonment in Assam Rifle custody on 18/6/2005 under Section 35 of the Assam Rifle Act 2006 for an offense of intoxication. C. To C. It is burden to mention here that the petitioner was administered counseling by the unit authority on a number of occasions. In order to afford an opportunity to show improvement in his conduct, a warning letter was issued to the petitioner in writing after he incurred 3 red ink entry in his office dossier. Right, so and so, dated 10/5/2015, annexure 1 to the writ petition, wherein he was categorically informed that and want to improve his personal conduct. Otherwise, administrative action to discharge him from service will be initiated as per the relevant rules. Despite having been advised many times, verbally and issuing of the written warning that to improve his conduct, the petitioner did not show any improvement for the better and breached the discipline again on 11/6/2015 for the offense of intoxication. The petitioner could not take advantage of the opportunity provided to him by the Commandant 23rd Assam Rifle, and on having incurred 4 red ink entries, he was identified to be an incorrigible offender, not likely to improve in near future. Thereafter, after complying to all the laid down procedure, action was initiated to discharge him from service as an undesirable and incorrigible offender, soldier. 2D. As per procedure involved, after incurring the 4 red entry, a show cause notice was issued to the petitioner by the Deputy Inspector General, Headquarters 7, White, letter dated 5/9/2015, that is annexure to the writ petition, giving him 30 days notice to send his reply.
Did he submit his reply?
Yes. The petitioner giving 30 days notice to send his reply. The show cause notice was received by him on 9/9/2015. A reply to the show cause notice dated 12/9/2015, annexure to the writ petition, was submitted by the petitioner, which was considered by the competent authority, that is the Deputy General, Headquarters 7 Sector Assam Rifle, and found to be unsatisfactory and lacking of any merit. Therefore, after an application of mine regarding the facts of the case, the reply to the individual, as he was ordered to be discharged from service with effect from so and so, under annexure 4 to the writ petition, under provisions of section 11(2) of the Assam Rifle Act 2006 with rules 17 and 25 of the Assam Rifle Rules 2010, the discharge of an irrevocable offender soldier from service is an administrative action of the department.
Report furnished to him, that is, I think, required.
That was furnished to him, Lordship.
Huh?
We have given all those documents was furnished to him.
What was furnished?
All the documents, the show cause notice was. It was their allegation that they have not received the show cause notice, but they have.
No,
Yes.
show cause notice he received and he filed a reply.
Yes.
But then the report of the commandant, of the Deputy Inspector General.
No, in this, while issuing the show cause notice, all the documents were furnished to him, which was received by him.
So he's saying that.
He has said that he has not received, but while issuing the show cause notice, he was given all the documents. That is what we want to see.
Receive it.
He is alleging that they have not received. He has not received.
That's a disputed fact again.
Yes, Your Worship.
Can you show something that he had received the documents as well?
No.
Then, okay. So, the discharge of an incorrigible offender shoulder for service is an administrative action. Okay, fine. Then 2E.
Well, Lordship, let me come to my Lordship. My brother friend has already referred to the annexures also. These are the page, starting from page 22. These are the summary court proceedings, the order of the summary court proceedings, Lordship.
That he is
That should-
satisfied, that
yes.
is saying that, okay.
So in the summary court proceeding, he was there in the Lordship, so he was personally there in the summary court proceedings. And thereafter, Lordship, in my Lordship account, he has, after receiving the notice, the show cause notice, he has given the reply that,
His reply is annexed by you or him?
yes, it's in my reply, Lordship. No, it is not in my reply, Lordship, but
Maybe it is in his petition.
Why?
in the,
Seventeen.
You have annexed your reply, right?
that is not in a way the reply, but he has given an apology.
Oh, yes, that
The
apology.
apology, yes, he has given apology only. He has not
That
given
is
any,
the only reply.
that is the only reply that he has apologized,
Okay.
which was considered to be his reply,
Huh.
which was considered to be his reply to the show cause. Which was considered as a reply to the show cause.
Appellant
Because he has apologized means he has
admitted.
admitted to the guilt. And even in the summary process, he has declined to examine any of the witnesses.
That is it. He did not even cross-examine.
Yes, he has not examined anyone, even himself, Lordship. So it is understood that since it is a summary court proceeding, that he has admitted to all the facts.
Then what you want to place?
I found an additional affidavit also. I don't know the date.
Affidavit in reply.
No,
It is
an
by
additional
him.
affidavit.
That is by him. Then? Yes, additional affidavit.
24/8/2023.
24/8/2023. Yes, I've got it.
Lordship, during the course of the hearing, that is before Justice Kesema, he has directed the parties to file an affidavit in opposition as to how that is, the order was on 27/6/2023.
In pursuance of the same, you have filed.
Yes, that during the course of the hearing, the writ petition, the Honorable Court made several observations and directed the petitioner to file an affidavit.
Where
Reading
are
the
you
report.
reading that?
This is my additional affidavit.
Yes, additional affidavit I've got. Where are you reading from? Just now that you have read.
This was filed on Lordship. I have not noted the date on my reply.
Achha, achha. Okay, that was the order.
Yes, this is the order, yes. The order stated that,
27/6
File
order.
as per 27/6 of.
yes, so as per the order of 27/6.
27/6.
Yes, 27/6/2003 was by the Honorable Court. I have observation and directed the petitioner file an affidavit written in report as to show cause as to how an Assam rifle personnel can be discharged on the ground of read entries in his service sources. So on the basis of the
You have filed this.
yes, I found an additional affidavit. Then in the service sources, Lordship,
Record of
in
this
the
instruction.
transfer Assam Rifle Regulation 2016
Regulation,
regulation, yes.
rule.
I have annexed the regulation in my
Oh,
my
you
affidavit.
annexed.
I have annexed in my additional affidavit, Lordship, the Assam Rifle Regulation 2016, page 4 of the additional affidavit.
Page 5.
Page 4. Page 4,
Okay, then, no, page 5, there are record branch instruction.
Record of instruction. Look, I think, Lordship, annex here F, I have filed 2 additional affidavit, Lordship.
Two edition.
This. This is the documents which I have annexed is the Assam Rifles Regulation 2016.
Assam Rifles regulation, where
2016.
you have annexed it with your AO,
Yes, me the additional affidavit.
earlier AO,
Yes, ma'am.
or the new AO, which AO? The AO you have filed after 27/6 order.
I have not recorded the date, so I have not recorded the date in my.
No, you tell, there are two AOs by you.
Yes, yes.
So one AO is the original AO where he had placed those documents. And the other AO is after the court's order.
Because of regulation, yes. In one, because the Assam Rifle records
Huh.
regulation. And in one, I have closed the Assam Rifle regulation.
There. Assam Rifle regulation. Record of his instructions are there.
Yes, Lordship, it's the same regulation, Lordship, the same regulation only. It is the same regulation, the same Assam Rifle regulation only.
Where? Which one?
In the
Where is Assam Rifles regulation?
Well, I have the copy with me.
And just give me.
We see the request. When there is an ad in the room,
Acha, what you want to show from the regulations?
it says this regulation being non-statutory, that is clear in their own regulation.
These are not enforced.
No, it cannot take the place of rules in the acts. That is what the preface itself is very clear.
Acha, what you want to place? Just please.
yes, I want to praise is that there is an Assam Rifle, or there is an Assam Rifle, there's Assam Rifle, like, yes, Lordship, but there is an Assam Rifle regulations also. The Assam Rifle regulation says that 2016 says that discharge on ground of red injuries.
Where do I find this? Here, in this
In-
book.
No, not there. In
Where?
the which I have annexed, Lordship, in the additional affidavit, yes.
See this and find out. This is an additional affidavit.
Yes, Lordship.
Where have you annexed?
In the additional affidavit, Lordship, I have annexed it.
See where it is. There are only instructions here.
Yes.
One. One.
Hay que explicar para el Está tu corazón. Maybe listen after the break.
Okay. We'll sit after the break. You take it out. And you can also check the file if you want. Otherwise, the punishments that can be imposed by the competent authority under the Assam Rifles Act
Yes.
is where? 62 only? 62,
No,
64?
57 it starts.
57 it starts.
These are major offenses. 62 is the only minor.
Minor.
That is as far as the enrolled person. 64,
And red it comes within minor.
After the break, Lordship.
After. You take out and.
Hello.
If I may intrude your lordship.
Yes.
Lordship, can you allow me to mention yesterday's matter? Item number 3, lordship. I couldn't mention yesterday because it came to my knowledge only after the order was uploaded. That was evening, lordship.
It's item number 3. I forgot, no?
It was a criminal petition. There's a clerical error in the council's name, lordship. Here is for ready reference.
Just show me the order. What was that? I forgot.
Lordship, it should have been S. Mary with regard to learned PP and not VZ moment. And it was the counsel for respondent number 2 who took time. And I have also mentioned for my interim extension, however, it's not reflected in my order. Therefore, if this order may kindly be rectified, Lordship.
Now that is already in past. When did I fix it? 21/7?
21, Lordship, next Monday.
Monday.
Yes, Lordship.
Let me see if something can be done or you have to, well, which one is that?
Lordship, if my interim is not extended, they may call for the matter.
You are for
in
respondent.
Lordship. I'm for private petitioner, Lordship.
You are for petition. Item
Lordship.
number 3.
Yes, Lordship.
I don't think so. Any prayer was made for extension of the.
I mentioned earlier, Lordship. We have in fact I verified with the steno. It is in the video recording, Lordship. If interim is not extended, it's
So,
likely
sir,
the matter will be pulled up.
Respondent number 2, V. Jimomi appears.
No, it's Pakin Richabo.
The name is also wrong.
Yes. V Zimomi is nowhere in this matter. It should be S Mary.
S. Mary.
Yes, with regard to learned PP. And with regard to the one who took time, it was for respondent number 2, that is Pakin Richabo.
If no CTC certified copy is obtained, then we can.
Yes, not
continue.
yet. No one has obtained so far,
I will see to that.
Lordship. Much obliged.
At 2.
Record to check. Really? Which is not. Jesus, no. This is one before as well. One to 20 photos. Transfer do all of within 9 into one. No, it do. Because I'm done.
Nah.
Yes, 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 I'm being called for which I mentioned.
In my case, no one tells guilty. Even without any speak out to see. As mandated, this is not mandated, as mandated. By the law, the petitioner was taking out another punishment for silence. This is this.
Rating increase were recorded. To appreciate comparison of rating increase recorded against. Yeah, one thing it is said that
May I please, Your Lordship, with
Yes.
regard to yesterday's matter, Lordship, item number 3, Lordship. There has been a clerical error in.
yes, you said that you had said that.
Yes, yes.
But then it was checked online.
Yes.
Then it was not found. Like no interim prayer was extension for interim prayer was made during the mentioning hours.
Lordship, if I haven't mistaken, I have mentioned it and like I just counter check it from the video recording. And
But like okay, number of the name of the advocate we will change.
yes, Lordship.
But since there was no prayer for extension, why don't you make one small application tomorrow and then it will be extended?
Uh,
Because people had taken out, it was made online.
right, Lordship.
And my private secretary had also seen the video.
Right,
And
Lordship.
prayer was not made according to him.
Okay,
So
if I haven't mistaken, we just checked it and I mentioned like there is an interim and if interim may be extended. I think that's the very word which I used and it's on record, Lordship.
but then now like when it was made online, now
Yes,
change
Lordship.
will not be proper. You make an application tomorrow
Lordship,
and
Lordship,
then we will extend it.
Lordship,
Okay.
Lordship,
Inadvertently it remained so for extension of the interim order.
Lordship.
I'm nowhere to I'm no one to advise you, but then it can be done in a way.
Lordship.
Okay.
Lordship. Much obliged.
Yes. You're supposed to show me that incorrigible part.
Yes, Lordship, incorrigible part. This under the Assam Rifle Rules 2010, Lordship.
Assam Rifles rules.
Rules,
Let's
Lordship.
look at that. Yes, what is the relevant section?
105, Lordship.
Hmm. 105 of the rules.
Rules, my lord. It provides resignation and primary voluntary retirement.
Wait, wait. This is 105.
Lordship, this is not the Assam Rifle Rules. This is the
Regulation.
regulation, Lordship.
Where is that regulation? I don't have. I have only rules. Is it there in this book? Regulation? Oh, you have given me this. Yes.
So I refer to the rating.
Good as a brother.
10?
Yes.
105.
105. This is 105 of the regulation, Lordship. The regulation provides that
Resignation and premature voluntary retirement.
the
107, I think.
yes, 108.
7 is removal of undesirable
Discharge on ground. 108 is discharge on ground of red ink entries.
Ah, yes. 108.
Yes.
Hmm.
So the rule says that as subordinate officer under officer or under enrolled person who has incurred 4 or more red ink injuries may be recommended for discharge from service on the ground of unsuitability subject to the following condition. After an individual has earned 3 red injuries,
He
he
shall
has,
be warned.
yes, he shall be warned in writing, which has already been done. And that his service will be liable to be terminated by the competent authority if he earns 1 more red increase. Such a warning letter shall be issued to him by the concerned commander through the commandant of the individuals. In the instant case, he has earned more than 4 red increase, show cause notice has also been issued to him, and he has received, and after that he was discharged from service. This discharge was done under 105 of the rules.
But I think in one of the judgment that he had shown, Amarendra, I guess,
Yes.
Amarendra, it is said that simply getting 4 readings
That's not.
will not entitle somebody to be terminated.
Yes, ma'am.
This is not a straitjacket formula.
Yes.
There's something in Amarendra's
Yes.
case, I think.
Ultimately,
Specifically the facts.
ultimately, the Supreme Court has passed an order in Amarendra's case that in civility, there's a similar facts.
Uh-huh.
Similar facts, Lordship. That case and this case is related to similar facts. In fact, so it is a covered case, in fact.
Where is that?
In the submission issued by the filed by the
Amarendra, I think.
yes.
Yes. So what about incorrigible part?
Lordship, it appears that in the Amaratam Kumara Dev case, yes, this which is what been related. Amarandam Kumar Dev case, same situation and same facts.
Yes.
So it's a covered. It appears to be a covered case.
What was done in Amarendra?
In Amaratam case, Lordship, he has entered more than 3 red
Which was
entries.
set aside.
Yes,
Acha. He is reinstated.
and reinstated, Lordship.
Okay.
That is the same facts as has been filed in this writ petition, Lordship.
But then see in Amarendra, what was the effect? Like he got red ink because of unauthorized absence and intoxication?
Intoxication, yes.
Same.
Yes.
Where is that? Show me in the case. That is 2211 SCR. What is the page number? Amarendra?
Relevant page is page 27. No, running page 28.
So what was the red ink given there? Why was that red ink given? Just show me these facts. Acha, for staying back to take care of his ailing mother. Acha, without sufficient cause. So it will not be 557 days for bringing on the way out to make a phone call, but stop before he could leave the compound. Visited out of bound areas as specified. Losing his luggage. for playing cards. See, no intoxication or being absent for 500 something days is not there.
Yes, Lordship.
There the offenses were less serious. It depends on facts actually.
It depends about the facts, Lordship. Yes, it will depend on the facts. And this case, in Amaratam case, I don't know what was the facts, Lordship.
Yes, then. Yes, then. What do you want to say further?
Lordship, in this case, it was about that severity of the nature of the conduct will be, have to be weighed.
Which
Will have to be
Amarendra?
weighed before,
Amarendra?
yes,
Which one? Which paragraph?
page 29, running case, page 29,
Hmm?
page 29. D, not D,
Placetum E.
D, capital
D,
D,
okay.
capital E is,
Mhm.
says commanding of, according to Lordship, discharge is not automatic. If Lordship.
No, I did not get. It was held that merely because a man receives 4. Discharge is not automatic.
Yes, discharge is not automatic. Thereafter, Lordship, direction is given to the commanding officer, not considering discharge, officer to consider discharge, the severity
Hmm.
and the nature of the misconduct will have to be weighted before recourse of that to be taken to exercise the power of conferred under clause
What
5.
is clause 5 of ROI? I think you have annexed in your petition, in your,
That is rigorous imprisonment,
huh?
ROI.
I think you have annexed in your AO, Nikki. ROI? Not AO, additional.
In the present case, Lordship, there's every other case is that he was intoxicated on 2 occasions and he absented from without the knowledge of without the authority of the competent authority. That's our charges.
Okay, that was settled. That was like, it was cut from his leave. What about the second one? Now, how many days incarceration was given? RI for?
RI for
7 days.
7 days.
No, no, no. B is RI for 28 days. 28 days. As far as B, C, and D, he is saying that there are no documents. There is no evidence, in fact. But then what your petition, did the documents?
All the
that you
documents
have
has been
annexed?
furnished, yes. There was nowhere in the affidavit also they have said that they have not received any documents also. That they have filed an RTI, but they were not given. Only that.
And oral evidence was taken. from
Yes, all
witnesses.
this evidence was taken in person. Witness was also, the witness has also signed in the.
But those evidence are not on record.
No,
like
this
it
is
is-
the record of the court proceedings, Lordship. Record is with office, Lordship. All the records are there. This is summary proceedings, and these are the records of the summary proceedings, Lordship. Lordship, see my affidavit.
Records perhaps is here.
Yes, records, all the records have been produced, Lordship. All these records were with him. He is aware of the proceedings, Lordship. But he is alleging that he has not
He
received.
was terminated which year? 2015, 16.
He was terminated, I swear the petition, 2015.
15. Now almost 10 years.
Almost 10 years. Yes, almost 10 years now, after he was discharged.
Then what else?
Who's my petition? Who's my petition? Uh, The discharge order was my prayer is that the discharge order was followed after following the due process of law. He has been given the show cause notice and he is given an apology letter. He has not stated that I have indulged in investigation or I have absented. He has already given a reply that he apologized for the deed, which confirmed that he is an irrecoverable evidence, offender's lordship. That shows that he has already given his reply due to notices, lordship. Other than the apology letter, he has not had any. He has not given any reply. He has not given any reply.
Effective reply. But then a region is cited by the authority, right? Before termination. Where are the regions?
I did not get it.
Before terminating him,
Yes.
where are the regions by the commandant, the authority? There has to
Documents
be
were
detailed regions, right? Let me see the implement order again.
yes, lordship.
Page 19. 180.
Give me
Yes.
the affidavit.
Was found unsatisfactory. That is all. Total qualifying service of so and so is Iman after deducting non-qualifying service. Now therefore being the so and so in exercise of so and so. The undersigned hereby discharges the said rifleman general duty. From the Assam rifle being an incorrigible offender soldier. Okay. Now, the requirement under Amarendra, the Supreme Court has said that in the discharge order, there has to be a speaking, or there has to be speaking. The discharge order has to be speaking, and does indicate how and in what manner
Yes.
the authority had exercised.
Not my lord.
So here, of course, they have said it was found, show cause notice given,
Yes, ma'am.
reply was found unsatisfactory,
Yes, madam.
and we in exercise of power, he being incorrigible,
Yes, lordship.
whether that would be sufficient.
No
Speaking
speaking order
order.
was issued, lordship, but the order of discharge was passed after considering all the documents. After considering all the documents, the discharge order was issued. All the documents were issued, were examined before issuing of the discharge order.
This is all.
Yes.
Yes, anything in reply or what? This is all. Okay, first of all, I'll dictate your submissions and all. I might miss out something. But the final findings, I'll deliver it in the chamber. Okay, but first I will dictate the facts and whatever you have submitted, huh? Because I might again forget. Thank Mati Devo. Because the rest of the part I will dictate in my bundle. So he will stay downstairs, so I can do it. Right, Bika is where? Adhika is?
He couldn't locate him.
Uh-huh.
He could not locate him.
Okay. Okay, she can take the first part. It's okay, you can take the first part and then the in the present petition, the issue that needs to be addressed by this court is to whether the termination of the petitioner from his service the termination of the petitioner working as rifleman, general duty by the competent authority in the Assam Rifles is lawful in the facts and circumstances of the case. The petitioner has filed this petition under Article 226 of the Constitution of India for a writ in the nature of certiorari for setting aside a writ in the nature of certiorari or slash mandamus for quashing of the impugn order dated 4/10/2015 passed by the Brigadier DIG, Office of the Deputy Inspector General Assam Rifles, Headquarters 7, Sector Assam Rifles, by which the petitioner was discharged from his service on the ground of being an incorrigible offender from his service with effect from 9/10/2015. The petitioner had the petitioner had also challenged the warning letter dated 10/5/2015 issued by the said authority, as well as the impugn show cause notice dated 5/9/2015 served by the, it's not served, given by the said authority full stop. The petitioner has also prayed for reinstatement of his service in the Assam Rifles. Full stop. The fact of the present case is that the petitioner was enlisted in the 23rd Assam Rifles to the rank of Rifleman, General Duty on 19/9/2007 with regimental number capital G /5013/723. And he was working in the said post since then. Full stop. During his service tenure, the petitioner was served with a warning letter dated 10/5/2015, issued by the Brigadier again, right? Comma Digar. Digar is what? Oh, DIG. AR. Digar. Capital letters. Stating that in his service of 8 years, 5 months, and 22 days, he had incurred 3 red ink entries in his dossier. Full stop. The details of the offenses were also mentioned in the said warning letter. Which are reproduced below. Just write this from A to A. Huh? I have mentioned it, and I have page number 15 of the petition. All are same. From A to A. Huh? In the said warning letter, the authority concerned had also informed him to be careful and that if he incurs a 4th red ink letter, action may be taken against him to discharge from his service under subsection 2 of section 11 of Assam Rifles Act 2006. Thereafter, the petitioner was served with a show cause notice this warning was on 15/5, right? Not 10/5, right? 10/5. And the warning was on 10/5. And on thereafter, on what show cause notice was issued, I said, no? Notice was issued on 5/9/2015. Upon the petitioner by the same authority, asking for a show cause reply from the petitioner. In this show cause notice, the authority has, in no unclear terms, had informed the petitioner that he had become an incorrigible offender and that it has become essential to initiate action against him in terms of section 11, subsection 2 of the Assam Rifles Act 2006. He was asked to reply as to why his service may not be terminated as per the existing rules. Full stop. In pursuance to the said show cause notice, the petitioner submitted a reply wherein he admitted his actions by stating inter alia that he was embarrassed for his own deeds and asked for apology and prayed that he may be reconsidered and reinstated in his service. Continue, right?
At that time, it was show cause.
Accepted his apology and prays that his service may be continued. Because he was not out by then, yes. Thereafter, yes, okay, then you write. The said show cause reply was in the nature of an apology only. However, on 4th of October 2015, the Brigadier de Guard had issued the impugned order by which the petitioner was discharged from his service as a rifleman, general duty, Assam Rifles, on the ground of being incorrigible offender soldier with effect from 9th of October 2015. It is this termination order. It is this discharge order that the petitioner has challenged in the instant petition, along with the show cause notice, as well as the warning letter mentioned above. Stop, Para. Mr. Your name, please. No, it's me. Your name, please, Mr.
IMT long term.
IMT Longchar.
One.
In fact, when I was in Guwahati also, I heard your name in so many petitions, I think. IMT Longchar.
From Gauhati.
Oh, yes.
In Saitya in Sham.
Okay, so I remember. IMT Longchar, appearing for the petitioner, submits before this court that the impugned order dated 10/5/2015 was written by the authority concerned without any documents or any details as mandated under Assam Rifles Rules 2010. He has relied on section 20, subsection 2 of the said rules, which reads as under. You can read the Assam Rifles rules, no? Hereinafter referred to as the rules. Start with inverted comma. Dot, dot, dot. It shall so inform him, together with all reports adverse to him, and he shall be called upon to submit, comma, in writing, his explanation and defense. Close inverted comma. He submits that as far as the first punishment, as mentioned in the impugn order, is concerned, which had entailed him 28 days incarceration in forced custody, he stated that the same was not unlawful inasmuch as there was an inquiry by the Court of Inquiry, right?
Yes.
If there was an inquiry, there was a full-fledged inquiry by the Court of Inquiry. It is in the AO.
Under Rule 183, Assam Rifle Rules.
Yes, inquiry by the Court of Inquiry, and the decision was taken for regularizing the said offense, and the same was debited from his leave account under Rule 183 of Assam Rules 2010. Assam Rifle, 183 of the rules.
That is Court of Inquiry.
Court of Inquiry, right? Where is the rules? This is 183, I'll just see once.
Rules is in that this.
Oh, yes. 183. No, let's change a little. What did I say? No, leave account. On the basis of Court of Inquiry, under Rule 183 of the rules. However, as far as the second, third, and fourth, offenses are concerned, the learned counsel submits that the same submits that there was no inquiry in respect of the same. But there was no proper inquiry in respect of the same. and that he was also not present when the purported inquiry was conducted. As regards the first offense is concerned, the petitioner is stated to have advanced proper reasons for overstaying his leave inasmuch as his wife was pregnant and that he had to take care of her as there was none to look after his wife. The said fact was also stated by the witnesses, by one of the witness during the inquiry before the court of inquiry. As far as the second punishment is concerned, the learned counsel states that there was no court of inquiry and that the punishment awarded by the commandant for absenting himself without leave from 19 to without leave from don't write without leave was erroneous. He also submitted that the second offense, that the date of entry of the second offense in the conduct sheet was on 3rd of March 2015, and immediately on 2nd of March 2015, third punishment was awarded. Which is again erroneous. As far as the fourth punishment was concerned, the learned counsel says it was awarded again for intoxication when on telephone duty was also erroneous. The learned counsel also submits that while serving him show cause notice, no documents were given in support of the same as mandated under the law. He further submits that the respondents discharging their petitioner, being an incorrigible offender under Rule 17 and 25, is against the rule, is against the rules. He placed Rule 17 of the rules, wherein it was stated, it was provided that termination can be awarded only on misconduct, unsuitability, unsatisfactory progress in training, furnishing false, wrong information at the time of enrollment, physical unfitness, on own request. As such, he submits that discharging an enrolled employee on being an incorrigible offender is not provided under the rules. He also stated that after the interim order, he had applied under the Right to Information Act to supply him the relevant documents, such as the appointment letter, the documents considered by the authority concerned while discharging him, but the same were not furnished to him. Mr. Longchar, appearing for the petitioner, had relied upon the following judgments to substantiate his point. Number one, Union of India versus Molendra Chaudhary, reported in 1998, 4 GLT 68. Balwant Singh versus Union of India, reported in 2011, 5 GLT 640. Amarendra Kumar Pandey versus Union of India, reported in 2022, volume 11 SCR 223. Rupesh Suryavanshi versus Union of India, reported in not reported. This is judgment, within bracket you write judgment delivered by the High Court of Meghalaya in WPC number 307 of 2011. Bracket close. Vijay Kumar versus Union of India. Again, you write within bracket, judgment delivered by High Court of Meghalaya in writ petition number 361 of 2011. The learned counsel for the petitioner also submits that the petitioner was punished twice for intoxication, as could be seen from the impugn order. And as such, he submits that the petitioner could not have been punished twice for the same offense, as that would be in violation of Article 20, Clause 2 of the Constitution of India, as well as what section you said? 62? No, 97. As well as Section 97 of the Assam Rifles Act. Assam Rifles Act 2006. These are your submissions, right? On these submissions, on these grounds, the counsel for the petitioner has prayed for the reliefs as mentioned above. On the other hand, Mr. So-and-so, appearing CGSC, right? You are the central government. Central Government Standing Council. You are CGSC, yeah. CGSC. Appearing for the respondent number 1, 2, and 3. Submits. And before that, you also write, Mr. So-and-so has submitted one written submission. Where the paragraph that you have written on these grounds, what did I say? By filing a written submission also. Somewhere you include that. Okay. On the other hand, CGSC, by relying on the affidavit in opposition filed by him on 6/4/2022, submits that
Before the impute order was passed, impute or discharge order was passed, the summary proceedings were held. The recordings of the summary proceedings are in.
those summary proceedings. I'll mention it in my listing,
Okay.
in my
Yes.
observations.
Madam.
Yeah, summary proceeding that you have annexed all this.
Yes, I have annexed in my affidavit.
Yes, yes. He submits that the petitioner was proved an incorrigible offender by holding 4 summary proceedings under the Assam Rifles Act. The first summary proceeding was done. And on the first summary proceeding, and an offense report was submitted.
These are not very eligible logic.
surface. With regard to the first offense, the summary proceeding was conducted as annexed, which is written, which is affidavit in opposition. And on completion of the same, the punishment was inflicted upon the petitioner for incarceration of 28 days in forced custody. With regard to the second offense, the learned CGSC submits a summary proceeding was again initiated. With regard to the second offense, that is
That's 26.
the petitioner absenting himself without leave from 1900 hours to 2240 hours while
Is it?
in duty, during his duty. Then you come, summary proceeding was again initiated and on completion thereof, punishment of RI for 7 days was inflicted. RI for 7 days in forced custody was inflicted upon the petitioner. Similarly, he stated that with regard to the third offense, that is, finding the petitioner intoxicated in unit lines, a summary proceeding was initiated and on completion thereof, the petitioner was inflicted a punishment of RI for 7 days in forced custody. Furthermore, with regard to the fourth offense, that is, the petitioner being found intoxicated on telephone duty, a similar summary proceeding was initiated and on completion thereof, the punishment of incarceration for 23 days in forced custody was inflicted. As such, he submits that the offenses were inquired into by the authority concerned and the punishments were inflicted as per the law. Further, he submits that on conclusion of these summary proceedings, a warning letter was issued to him. Right? Warning letter was issued to him on 10/5/2015, by which the petitioner was warned that he has already obtained 3. Oh, no. The fourth one was after.
After 3, he was given a yes.
Before this fourth one, before the fourth one, you write this. He submits that on completion of the said 3 summary proceedings and on infliction of the punishments, a warning letter was issued to the petitioner intimating him that 3 red ink entry had already been inserted in his service document and a fourth one may make him liable for discharge from his office.
Which was duly received by him.
Mhm.
Which was duly received by him.
Huh. Which was duly received by the petitioner. However, then you say, however, on, however, the petitioner, however, the petitioner did not reform his character, and the fourth offense was committed by him. Then you could go to fourth one. Okay, fourth offense was committed by him. The counsel further submits that a show cause notice was thereafter issued to him. As to why? There was the show cause here. What?
Page 18.
Huh?
At page 16 of the
Petition.
petition.
16. No, not 16. Right? Oh, yes. Yes.
Of the writ
16.
petition.
Okay, I got it. Mm. Issued to him, intimating him as to why action may not be initiated against him to terminate him from his service in view of the red ink entries. To which the petitioner replied,
He
We
did not
can
reply, but he
prayer
only,
for-
he did not reply in fact, but he has
Yes.
given an apology of letter, admitting that he.
in the nature of, he
Yeah, reply,
replied,
that what this was taken as a nature of reply.
nature of prayer for apology. No, the petitioner submitted a prayer for apology in the nature of a reply.
Yes.
He thereafter stated that the reply was not found satisfactory, and as such, the impugn order was passed on 4th of October 2015.
Well, that is the facts of the case.
And in the facts and circumstances of the case, he submits that there was no violation of any provision of the rules or the act and the rules. And by following the proper procedure of law, the petitioner was terminated from his service.
Yes.
This is all.
That is the facts, yes.
These are your submissions. The rest I will dictate it in the chamber. File properly. I have heard Mr.
Gauhati.
So and so and
HTC.
so-and-so at length. Full stop. On the aforesaid submissions, this court is called upon to adjudicate as to whether the punishment imposed upon the petitioner was correct in the facts and circumstances of this case. Then I will go with the.
What?
Today only I'll finish. The matter is disposed of. No other matters. No. Give me everything there in the chamber.
What?
Thank you.
All the parties. And that's when you.
Fuko, Vincent, Kevin, Sushi. হলো পট্টু খতম হয়েছে রে